this again. All right. Yes, good. Okay. We'll start again. All right. So question here is we have IRAs and we have non-qualified accounts. We want to name them to the trust. IRAs or any qualified accounts, we name the trust as we name the spouse as a primary beneficiary, trust as a contingent beneficiary, because the spouse can do what's called a spousal rollover, where they don't have to take out any RMDs, and it becomes basically their IRA unless they already have to take out their own RMDs because they're either 73 or 75. Now, non-qualified accounts, with a revocable living trust, we almost always name the trust as the beneficiary. And really, there's two ways that you can leave things to the multiple beneficiaries. One is you just name the general trust, okay? So it would be like, all right, I'm leaving everything to the Smith Trust. And then you let the trust then distribute the beneficiaries. The other way you can do it is you can leave it to like the individual trust, like the Smith Trust for the benefit of child one. Either way is going to work. In the past, a more conservative approach would be to leave it to like Smith Trust for the benefit of child one, Smith Trust for the benefit of child two. But really, this would only be for like pre-tax accounts. The idea was that sometimes we'd have custodians that might screw up that stretch aspect, which really was a big issue prior to the Secure Act, where depending on how the trust was set up, it could potentially not qualify as what's called a designated beneficiary, which means instead of getting the full stretch, you'd have to pay all the taxes within 5 years. So an easy way to avoid having a trust that might have these problems would be naming the like sub-trust that pops out of the initial trust. With all of our trusts, the way we set them up, there's no chance for it to not qualify as a designated beneficiary. So that's where I just go back to the easy answer, like you don't have to overthink this, is IRA, spouse trust, or spouse first, and then trust as beneficiary, non-qualified accounts, name the trust. The rationale for the TOD is the child two and the grandchildren will be getting financial just prior to death for education. Yeah, so I wouldn't, you can look at, so I think what this is getting to is like, hey, let's break while I'm alive, break the IRA into separate accounts. You can do that. I just think it's overcomplicating things. But if you want to make sure, like if you're giving distributions to a beneficiary while you're alive and you don't want to adjust it in the trust, then what you can say is, okay, I want account 123 to go to child one. And so whatever's left in account 123 will go to child one. So you could split it into separate accounts. We don't typically do that, but you certainly could. And so that would be a way that if you're giving, or even if it's a non-qualified account, not just IRAs, any type of account, if you're giving money to say a child or grandchild while they're alive, then that could be a way that you do it. So you would have like, if you have 4 beneficiaries, you could have 4, you could break your accounts into 4 separate accounts, and then you could leave just each account to that beneficiary. But either way, I would just leave it to like one general trust and then just have the trust say that account 123 goes to this child and whatever value is in there. So I think that would be an easier way to handle it versus naming like sub trusts and stuff like that. Reason I don't really like the idea of like naming all these sub trusts is I can see families kind of screwing that up because funding already is pretty difficult and we create funding tables for our clients. So I want to make their job as easy as possible. So I would typically name everything just to the Smith Family Trust or Smith Living Trust. And then in the trust document, say account 123, whatever value is in there, it doesn't matter, goes to child A. So I think that'd be the easiest way to handle that. All right, here's another question. Okay, that one's done. And again, if you do have any other questions, feel free to put in the Q&A. Otherwise, I have one more here I'm gonna take care of. Paste. All right, share my screen. All right, so here's a question. Can you guys hear? Yeah, there should be audio at this point. It's showing up on my end. Can mom and dad sell their primary, can mom and dad sell their primary home, then move into the vacation home up north full-time for at least 2 years, and when they sell, avoid paying capital gains on that up to a $500,000 limit? So mom and dad, so yeah. So yeah, so we have mom and dad, they're gonna sell their primary home, and then what's gonna happen is they're purchasing a vacation home up north. And I guess there's two situations. One is, yeah, and again, I'm a little fuzzy on this off the top of my head. That's why we have a CPA. But my understanding is that they have to be in the home for 2 years, and then each one of them gets a $250,000 exemption with regards to capital gains if they were to sell. So yeah, if they were to sell and there for 2 years, there's no capital gains that they would owe. The other situation would be that if they pass away, they automatically get step up in basis. So the kids would have zero capital gains as well. So yeah, so typically with primary residence, there's a way to get around the capital gains, whether we're using the $250,000 exemption or $500,000 exemption for a married couple, which again, I'm pretty sure you have to be there for 2 years, like you mentioned. Or if they do still own it when both of them pass away, the kids get step up in basis. And so there's no capital gains when the kids go ahead and sell. So I don't think there's going to be a capital gains issue in that situation, because most likely one of those two outcomes will happen. So, all right. Any other questions? All right. So sorry for some technical issues this time. And again, no webinar next week. If you do have questions, feel free to submit them, and then we'll take care of it 2 weeks from today. So with that, thank you, everyone. Make it a great week. Take care. Bye-bye. Bye-bye.